she continues to violate this court's order, despite the referee's recommendation admonishing her for same. We are now going on 4 months of the child being in a choice of school of her choice only, that only benefits her.
This case wastes no time jumping straight into chaos. We're dealing with a high-conflict custody battle where school placement, procedural deadlines, and alleged court order violations are all colliding at once. One parent says the system failed them on a technicality, while the other claims this is a pattern of delay and defiance. And at the center of it all, a child whose education and stability hang in the balance. Buckle up, because this courtroom is about to get very real very fast.
Cronin Mead, or also known as Della Rollins, and Brandon Mead.
Attorney Kyle DeBrucker with and on behalf of the plaintiff Della Rollins, who is seated with me to my left on the screen.
Your Honor, Jordan A. Schoenbrod on behalf of the defendant Brandon Mead, who last I knew was in the waiting room, and I do not see him.
I do see him on my screen now, so I believe he's here with us. Are you here, Mr. Mead?
Yes, sir.
All right, thank you. So it looks like we have counsel and the parties. Got a bunch of busy stuff going on with this case, so let me get it set up here in my file. Looks like we have a request for to set aside the referee's recommendation, and then we have a objection to the referee's recommendation. I believe that's all the same thing from the plaintiffs. So let me hear from the plaintiffs first, and then we'll hear from the defense, and then we'll see where we go from there.
Yes, Your Honor. Thank you. We are requesting a de novo hearing pursuant to MCR 3.215. Under that court rule, the court may conduct a hearing, take additional evidence, or order that the referee conduct a further hearing when necessary to properly decide the issues, and that's what we think is going on here in this case. The referee's recommendation rests on materially incomplete record, particularly as it relates to the child's school placement, which, as we all know, is a significant joint legal custody issue that directly implicates multiple best interest factors.
Let me interrupt you for just a second. I think that there's 2 steps to this process. One is that there was already an order entered adopting the referee's recommendation. Is that correct?
That is correct, Your Honor.
So you're asking me to set that aside based on some service issues that you had trying to get that objection here in a timely manner. Is that correct?
That is correct, Your Honor. And just for additional context, I think I even misspoke in my motion for reconsideration in that I believe I indicated that we gave opposing counsel notice on the 16th prior to the deadline. She was actually given notice on the 15th. We did overnight our objection to get to the court the next morning, and apparently did not get there until the day after the deadline. That's our own deal with UPS and as to why that occurred. But we would argue that certainly Dad has not been prejudiced by this delay. I think that's even more evident in the fact that he was able to file a response to our objection. So as far as I'm aware, because it was never brought up to me, I didn't notice that this was late until we got the signed order through a records request that we realized that there was a problem. So we would argue that nobody's been prejudiced by the delay. We're here today. And we would ask that, based on the reasons outlined in our motion, that the court could constitute the delay as an excusable mistake or neglect, however you want to word it. But I don't feel disposing of the objection and request for a de novo serves the children's best interest just because of a technicality.
All right. As to that limited motion to set aside the order based on the service issue, defense counsel, your response?
Well, Your Honor, I don't have that. Well, I see it now because my assistant brought it in because in my mail this morning, this motion to set aside, I see at the bottom of his cover letter, he says he emailed it to me. I presume November 5th, the date of his cover letter. I did not receive that via email. So I have not even reviewed his motion to set aside. I am aware that he is making that request. My position is I see it in his motion now that he states his client retained him a couple days prior to the objection period. This is kind of her MO in this type of case. It's happened in motions before where she is not timely. She withdraws the motions after my client spends significant fees defending them. And so my position is that the court should uphold their order and that it wasn't filed timely.
Your Honor, if I may offer some quick insight, I also don't know the veracity of the truth as to what counsel just stated regarding, prior filings or being withdrawn. I will point out that even when I look at the register of actions, my client had less than 7 days notice for this evidentiary hearing. It doesn't even look like for this February or September 15th hearing, the actual notice of hearing was not prepared until September 9th. So procedurally, I think my client was at a disadvantage. I think that pertains both to this issue as well as the request for the de novo. But nonetheless, I do not think that dismissing this based on a technicality serves the children's best interest, the child's best interest in any way, shape, or form. And we're here. I do not know why we would not just continue as planned.
All right, I'm going to agree to set aside the order adopting the referee's recommendation because I do believe that plaintiff's counsel had it answer ready prior to or had an objection ready prior to the expiration of the time period, but there was an issue with overnight mail, which he has documented in his motion that appears to me to be while he was skating very close to the edge as far as the time limit, he did take action, substantial action within the time limit that normally would have gotten the objection to the court within the normal time period. It was but for the court's efficiency where I entered the order on the first day that it was possible to enter that order. In most courts and quite frankly in this court, normally it would have taken a couple of days and the documentation would have been here in a timely manner. So for those reasons, the procedural technicality of it, I am going to grant the request to set aside the.
This is a pivotal moment. The judge just ruled that procedural fairness matters more than rigid deadlines, at least in this instance. By setting aside the referee's recommendation, the court is saying, yes, the objection was late, but not so late that justice should be ignored. This is huge because it reopens the door on a custody-related school decision, which legally qualifies as a major joint legal custody issue. The question now becomes, does fairness outweigh finality?
Order adopting the referee's recommendation and find that the objection was timely entered, which brings us to, so counsel, if you would, plaintiff's counsel, if you would prepare an order that grants that motion for my signature, I would appreciate that. And then that brings us to today where there is the request for a de novo hearing. So I'll hear argument on whether or not we should have a de novo hearing, and then we'll set, if that's granted, we'll set a time in the future for the actual argument. And because I've not had a chance to review the referee's CD or the video of that yet. So we'll hear some argument on whether or not we should have a de novo hearing. So I'll allow plaintiff now to argue that motion. Go ahead, sir.
Thank you, Your Honor. As I was just mentioning, this hearing was originally scheduled for October 15th, the referee evidentiary hearing. And then suddenly, I believe my client got notice on September 8th that the hearing was now being moved up to September 15th. The notice for that hearing was actually prepared on September 9th. And I think that leaves her at a severe disadvantage. She did try to get officials from both schools as well as other witnesses to appear for that hearing. Of course, she is not an attorney. I understand that she didn't know how to subpoena these witnesses, but I must say, even if I had 6 days notice of a hearing, I think it would be very difficult for me to get witnesses subpoenaed for an evidentiary hearing on such short turnaround. So with that, I think immediately she was at a disadvantage for this hearing. And first of all, the referee did not hear, because of this, testimony from any personnel at the child's school, the prior school, or the current school. Yet these are the individuals who teach, evaluate, and observe this child daily. It's not just based on subjective opinions of the parties, and we believe that these witnesses would have central facts under several best interest factors, particularly B, H, and J. Without that testimony, the referee clearly lacks a complete evidentiary basis to assess the child's schooling needs and whether or not the 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 current school versus the prior school, who is better equipped to accommodate the child. Not to mention, the referee didn't hear any testimony regarding other options as well, such as other schools, homeschooling, whatever else there could be. I think it's also important to note that this objection appeared, or the recommendation, Your Honor, appears to be more heavily focused on sanction driven regarding my client and her procedural deficiencies in going about this, rather than what's actually in the child's best interest. So we believe that the Michigan courts have recognized that this de novo process exists to ensure that the judge and the referee can make the ultimate decision on contested issues based on a complete record, and that the court uses the de novo hearing to receive additional evidence where the referee's record does not adequately address the child's best interest. And that's what we think is going on here. We don't believe that this is a minor issue. The school placement is significant. It affects the child's stability, daily routine, connections, access to academic supports, which I think is clearly controlling in this case, simply because this child does have an IEP. And this kind of decision of this magnitude should not rest on a partially complete record. We are not asking the court to rehear this matter. We're not asking the court to relitigate. We're just asking to supplement additional testimony so that this court can make a proper decision in the child's best interest. At the end of the day, Your Honor, I think the process here was procedurally deficient itself in the fact that there was such short notice for my client to gather these witnesses for this hearing. And we would just ask that this court either send this case back to the referee in order to conduct some supplemental testimony, or this court can hear that on a de novo hearing. But we would ask that this court allow my client to present that evidence and testimony.
Defense counsel?
Thank you, Your Honor. First, I rely on all of the arguments set forth in my response to plaintiff's objection. The fact of the matter is Ms. Rollins failed to properly prepare for what was a 3-hour evidentiary hearing. She can claim all she wants that she didn't have time to prepare, but my client had the same amount of time. She filed to my office 3 days before the evidentiary hearing a list of proposed exhibits and witnesses. She failed to call witnesses. She failed to and I will disclaim my colleague did handle the evidentiary hearing. So to my knowledge, she did not submit any evidence at the evidentiary hearing. She could have raised procedural issues at that time or timeliness issues, and that was not done. In fact, now she's retained counsel just days before the deadline. And as we just went over, had issues getting an objection in timely. And now she does want to relitigate this whole case. Her whole 60-some paragraph objection sets forth what evidence she will present, what witnesses she would like to call. All of that would have been available and was available to her at the evidentiary hearing. She filed an ex parte motion trying to change the child's school. It was denied. My client did the same thing to try to prevent the change of school. That was denied. And there were several hearings noticed. My office had to call the court numerous times to make sure we were prepared and that what was noticed was actually what was happening that day. She could have done the exact same thing and failed to do so. The fact that she was underprepared for, again, what was a 3-hour evidentiary hearing, it would be prejudicial to my client if this court allowed another full-blown evidentiary hearing. Pursuant to MCR 3.215 F2, this court does have discretion to limit witnesses and exhibits that were available to her at the time of the evidentiary hearing. Frankly, I don't think a de novo hearing should be granted at all in this case, but if one is, I would request that they are limited to new evidence available after the evidentiary hearing, which frankly will only be detrimental to her because the child is not doing well in his current school. I also do want to point out that she continues to violate this court's order despite the referee's recommendation admonishing her for same. We are now going on 4 months of the child being in a choice of school of her choice only that only benefits her. The child, again, is doing extremely poorly. And for sake of arguing against my own argument of bringing up new evidence, this cannot continue to go on. We have a show cause motion pending, and I believe sanctions should be granted against her, and the child.
This is where the temperature in the courtroom spikes. The defense is accusing the mother of knowingly violating court orders for months, while simultaneously arguing the child is suffering because of it. But here's the tension. Those claims aren't backed by live testimony at this stage. So let me ask you, should allegations this serious carry weight without fresh evidence? Or is this exactly why courts are cautious about reopening records? Drop your thoughts below, because this argument cuts both ways.
Should immediately be replaced in Gaylord Community Schools.
May I have a brief response? Yes, thank you, Your Honor. So first of all, I would caution the court as to allowing counsel to provide facts that have not been proven or testified to regarding how the child is currently doing. I will say that I think it's even more concerning that neither one of these parties actually reside in this district anymore. I can't even sit here and say today that this child could even be allowed back into the Gaylord School District. My client has sold her home, and it's not just as simple as, well, it's in this child's best interest that we limit this witness testimony. This court's job is to determine what is actually in this child's best interest. And the only way they can do that is to get a full record to review. I would say that these witnesses weren't available on such short notice, and I do not think any witnesses should be limited. I don't think that my goal here is not to have cumulative testimony. It's not to put my client back on the stand to testify to what she already did, but it would be my intent to take a few hours to get the people in here, and maybe the court's opinion changes, maybe it doesn't. But I think by giving my client less than 7 days notice for this hearing did put her at a disadvantage. I do think that's a violation of her due process. And at the end of the day, we don't feel in any way, shape, or form that any of this is to serve the best interest of the child rather than just sanction my client.
May I respond, Your Honor?
No. How is it that your client, plaintiff's counsel, didn't have notice, didn't have preparation time when she didn't bring the issue of changing schools to the court's attention until the end of August? How is it that she would not have proper notice that a hearing would be required and that witnesses and school information would be necessary when she waited until August the 28th to even file a first motion regarding changing school systems beginning the next weekend or after the next weekend, after the Labor Day weekend? So
Yes,
how
sir.
is it that she did not have sufficient time to file a motion and gather the witnesses and evidence that she needed during the entire length of the summer preceding her motion?
And I think that's a fair question, Your Honor. I think that just lends questions to the timeline here. My understanding is that my client had discussed this with the opposing party, and it wasn't until the end of summer that he indicated he wasn't okay with this arrangement. That's my understanding. And at that point, was well underway of already. I mean, obviously, she had to take steps to get this child into this school ahead of that filing. It wasn't until it was clear that he wasn't actually agreeing to anything and that this was a legitimate problem and that she learned what the process was that she did file that motion. And from when I look at it, it was kind of a messy start to the case and the fact that there were several ex partes filed. The best procedure probably wasn't followed here, and hindsight is 2020. But nonetheless, I think that's still different. She filed the motion. I can't even say if she knew who the teachers were at the new school at the time that she filed that motion. But even then, in my experience with these school officials, they're not going to show up unless they do have a subpoena. And you get that advice from their counsel. So she filed this on the 28th, and then there was a hearing on the 15th. I still think there was no way for her to know when a hearing would actually be scheduled, especially since the original notice was for October 15th and then got pushed up a month. So that was just kind of unusual, I think, with the timing.
It was unusual because the court wanted to make a decision before the child was in school for any length of time, which is how that decision is supposed to be made. It's supposed to not jerk a child out of a school system and bounce it back and forth. And the court had no way of knowing which way the case was going to go. So we set it as early as possible so that we could make a decision that would not unfairly jerk the child around if a decision to the contrary was made. I think the court did everything in its power to make amends for the mess that the plaintiff created. We tried to have a hearing as quickly as possible so that neither side was prejudiced and the child was not clearly prejudiced by moving school districts. She's the one who made the unilateral decision to move the school districts without prior court intervention, which is something that just simply should not be done, period. She did it. She bears the consequences of that decision. And the consequence is there was a shorter timeline. That's not the court's fault, and it's not the defendant's fault. She had every time to gather the evidence during the summer. She didn't make a decision to go over to the Traverse City area or the Forest Schools area on August the 28th. She had that decision made many weeks in advance of that. So she's had plenty of time, in my view, to gather that evidence and to have those witnesses available ahead of time. The fact that she waited until the last minute to gather the evidence is nobody's fault but her own. So no, I under the statute, I'm not going to give her the ability to call witnesses that she could have had previously. NCL 552.507, subsection B, subsection 6 says that a de novo hearing includes a new decision based entirely on the record of previous hearing, including any documentation submitted there. And that's what we're going to do. I'm going to make it on the information that was available to the referee at that time. The court has the discretion under that statute to prohibit the party from presenting evidence that was not objected to determine the referee's finding conclusive as to any fact that was not objected to, and to prohibit the introduction of new evidence or use of new witnesses absent showing that the evidence was not available at the referee hearing. I believe that that evidence was available at the prior referee hearing for all the reasons I've stated on the record. So I will grant your request for a de novo review. I will make that de novo review based on the information previously provided to the referee, and I'll issue my written opinion as quickly as possible thereafter. Defense counsel, if you prepare that second order with that ruling, I appreciate it. Is there anything else that we need to do today, counsel?
I don't believe so, Your Honor.
Thank you very much. That's all then.
In the end, the judge strikes a careful balance. A de novo review is granted, but strictly limited to the evidence already presented. No new witnesses, no second bite at the apple. The court makes it clear, unilateral decisions, especially involving a child's school, carry consequences. This ruling reinforces how critical timing, preparation, and compliance are in family court.
Thank you, Your Honor.